The shockwave hit hard. Before most Americans even woke up this morning, the Supreme Court quietly altered how power functions in the United States. What some Americans now term as sanity restored after decades of failure and hopelessness. No warning, no public debate, no televised arguments, just a sudden 6-3 emergency ruling, one that will begin affecting millions of people as soon as next month. And here's the part almost no one is talking about yet. This decision doesn't simply adjust a policy or resolve a narrow legal fight. It fundamentally changes how your rights are protected in this country. Whether you realize it or not, the legal ground beneath your feet shifted overnight. This isn't just another Supreme Court headline. It's a tectonic shift in power between judges, presidents, and the American people. From state capitals to federal agencies, from courtrooms in Washington, D.C. to California, the rules of the game were rewritten in a matter of hours. And most people don't even realize it happened. Before we break down the details already sending shockwaves through the legal system, make sure you're subscribed, because this is exactly the kind of Supreme Court decision that doesn't feel real until it affects your life directly. Late last night, the Supreme Court issued a 6-3 emergency ruling in Trump v. Casa Inc. through what's known as the shadow docket. That means no oral arguments, no months of deliberation, no full public briefing. Just a rapid decision that immediately reshapes the legal landscape. On the surface, the case involved a high-stakes executive order tied to birthright citizenship. But the court used this case to do something much bigger. It resolved a decades-long internal battle over judicial power, one that's been quietly building behind the scenes. At the center of this ruling is a concept most Americans have never heard of, but have relied on for decades. The Supreme Court just ruled that federal judges can no longer issue universal injunctions that block a law or policy from being enforced across the entire country. That may sound like technical legal language, but the consequences are enormous. This single decision rewrites how constitutional challenges work in America. For the past 25 years, when someone challenged a law they believed was unconstitutional, a single federal judge could temporarily stop that law from being enforced anywhere in the United States, while the case moved through the courts. One judge, one courtroom, one order, and the entire federal government had to hit pause nationwide. That power was used in cases involving immigration, healthcare, environmental regulations, gun laws, workplace rules, and voting procedures. A judge in California could freeze a policy in Texas. A judge in Texas could block a rule from taking effect in New York. That era is now over. The Supreme Court didn't just limit that power, it eliminated it. According to court filings reviewed this morning, there are currently 68 active nationwide injunctions affecting everything from prescription drug access to workplace safety and election administration. Under this new framework, many of those injunctions could collapse within the next 60 to 90 days as lower courts scramble to revise their orders. And the timing couldn't be more volatile. We are heading straight into an election year, with major battles over immigration, healthcare, civil rights, and voting rules. This ruling just changed how every one of those fights will be fought. The majority opinion was written by Justice Amy Coney Barrett, joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Thomas. Their argument rests on a simple but radical claim. The Judiciary Act of 1789 never gave judges the authority to protect people who aren't actually parties to a lawsuit. According to the majority, a judge's role is to resolve specific disputes between specific people, not to act as a nationwide veto over presidential or congressional action. But honestly, the most explosive reasoning didn't come from the main opinion. It came from Justice Gorsuch's concurrence. He traced court practices from the founding era through the late 1800s and found something striking. Historically, American courts refused to issue injunctions protecting people who were not directly involved in a case. Judges repeatedly declined to extend relief beyond the actual plaintiffs standing before them. Justice Thomas went even further, arguing that nationwide injunctions are a modern invention that encourages forum shopping, where advocacy groups search for sympathetic judges to shut down policies they oppose. According to the majority, that era is now officially finished. The dissenting justices saw this very differently. Led by Justice Sotomayor, they warned that stripping courts of universal relief gives the executive branch the ability to enforce unconstitutional policies, while individual lawsuits crawl through the system one by one. The dissent warned that this ruling risks turning constitutional rights into privileges, reserved only for those who can afford to sue, and that's where Part 1 ends. because the real impact of this decision is no longer theoretical. It's already unfolding in real time across immigration, gun laws, healthcare, elections, and the economy. Within 48 hours of the ruling, the legal landscape shifted dramatically. Attorneys general from 18 states rushed into federal court, filing emergency motions, some trying to preserve existing injunctions, others racing to enforce laws that had been frozen for years. Texas moved quickly and aggressively to narrow injunctions blocking immigration enforcement. Florida filed emergency briefs aimed at social media regulations and election procedures. California and New York responded with filings of their own, scrambling to preserve nationwide blocks on federal policies they oppose. Behind the scenes, the Department of Justice convened emergency strategy sessions, pulling in hundreds of federal attorneys across dozens of active cases. The White House counsel's office quietly warned federal agencies to prepare for laws they believed were blocked to suddenly take effect, possibly within weeks. The speed and scale of this reaction say everything. Legal strategists view this ruling as a major power shift toward the executive branch and a serious blow to judicial resistance. Advocacy organizations across the political spectrum are now in scramble mode. Groups like the ACLU, NAACP, and Alliance Defending Freedom relied on nationwide injunctions as their strongest legal weapon. That weapon is now gone. Major law firms are warning clients that civil rights and constitutional litigation could now cost 5 to 8 times more. Because instead of filing one lawsuit, plaintiffs may be forced to sue in dozens of jurisdictions. This is where the ruling becomes deeply personal. Immigration enforcement is ground zero. Right now, there are 19 injunctions limiting ICE practices nationwide. Under the new framework, those protections may apply only to specific plaintiffs in specific districts. Immigration enforcement could now look entirely different depending on where you live. The same is true for gun rights, healthcare access, environmental protections, workplace rules, and voting laws. Your rights may now hinge on your zip code. We may be entering an era where federal law exists on paper, but is enforced unevenly across the country. 50 versions of the same law, one constitution, fragmented protection. As we move toward the 2026 election cycle, this ruling sets the stage for unprecedented legal chaos. Election administrators are already warning of nightmare scenarios where voting rules vary, not by state law, but by court geography. Corporate America is panicking as well. Multi-state companies now face the prospect of complying with different federal rules in different regions. Banking, healthcare, technology, and pharmaceutical industries are all warning of massive compliance costs and regulatory confusion. Estimates suggest this legal fragmentation could cost businesses tens of billions of dollars every year. But this story goes even deeper. This ruling is part of a broader Supreme Court strategy that leans heavily on the shadow docket, where high-impact decisions are made without full briefing or detailed explanation. By issuing emergency orders that quietly reshape the law, the court is asserting control over lower courts in ways that would have been unthinkable just a decade ago. Critics warn this creates a chilling effect, where judges hesitate to block even clearly unconstitutional actions out of fear of swift reversal. For civil rights, the implications are profound. For decades, broad injunctions were the primary tool used to dismantle systemic discrimination. Now, courts may only protect the small number of people who sue, leaving thousands of others exposed unless they file cases of their own. Justice Jackson called this an existential threat to the rule of law, warning that it creates zones where the Constitution effectively does not apply. The Supreme Court's 6-3 emergency ruling in Trump v. Casa Inc. didn't just change a legal procedure, it changed the meaning of protection in America. If your right to vote, to equal protection, or to due process only exists if you personally have the resources to sue, then those rights begin to look less like guarantees and more like privileges. We are entering a new era of American law. Whether this represents a return to constitutional originalism or a dangerous fragmentation of justice depends on your perspective. But one thing is certain: the legal patchwork is here, and its consequences will shape immigration policy, elections, civil rights, and economic stability for years to come. If you want to stay ahead of these changes, make sure you're subscribed, hit the like button, and tell me in the comments. Was the Supreme Court right to end nationwide injunctions, or did it fracture the rule of law? Your answer may say more about the future of America than you think.